Good morning, Ya Arif. My name is Shari Zamzani bin Abdul Kamis. Appearing in this honorable court, I am the senior counsel on behalf of the appellant Karima binti Abdul Ghani and 66 others. We would like to argue that the appellants are entitled and have the right in law and in equity to compel the respondents to compensate them fairly and fulfill their promises, since the appellant occupied the said land area before the establishment of the PKENK. The appellants submit that they have the occupational right and personal right over the land as a toll holder, and they have rights of the land according to the principle of equity, which are he who comes to the equity must come with clean hands, and equity follows law. Thus, the appellants occupied the said land area before the establishment of PKENK, and a verbal agreement has been made by the respondents. The appellants have the occupational right and personal right of the land as the toll holders, as stated in Section 425 of the National Land Code, which defines quarters as any human occupation of land without the approval of the local authorities. And this, in the case of Siddiq bin Haji Muhammad, the government of Malaysia, this honorable court held that the only way to obtain state land is by way of an LC. In the case of Sentul Muni and Ahmad Amiruddin bin Kamaruddin, the appellant applied to recover possession of the disputed land on the ground that the appellant is entitled to possession, and the respondent is in occupation without license or consent. The court held that the respondent could only have the right to occupy the disputed land only if they had obtained the license to occupy the said land by the way of an LC. In this instance case, since the tolls have been granted by the Kelantan State Authority to the appellants, by implication, they are entitled to occupy the land since they have obtained the toll by the way that have been provided and consistent with the National Land Code. In Section 67, Subsection 3, the renewal of toll for a term not more than 1 calendar year, and there shall not be more than 3 renewals except with the approval of State Authority. And in the present case, the tolls have been granted by the Kelantan State Authority to the appellants in 46 subsequent renewals duly approved by the Kelantan State Authority exceeding for the period of the first 3 years of renewals. The appellants are entitled to occupy the land, and thus the appellants have occupied the land lawfully. Hence, in conclusion, the appellants are the toll holders rather than squatters, and therefore the appellants had obtained the legal right in law since they had acquired the legal license and stayed in the land within lawful occupations. And the appellants also have the rights of the land according to the principle of equity, which are he who comes to equity must come with clean hands, and equity follows the law. In the case of Adraji Banking and investment in Hafsa Food Industry, the principle of he who comes to equity must come with clean hands can only be applied when the appellants have gained their right in good faith, i.e. ground for validity in certain legal situations. And in Kwan Pak Seng and Robert Doran, the court held that if the appellant wants to apply the principle, the appellants must obey the existing law. And in this instant case, the appellants obtained the tolls which were granted by KSA, Kelantan State Authority, and shows that the appellants fulfill their obligation in renewing their license every year for 46 renewals lawfully until 2015. And moreover, the appellants have occupied the land with tolls applied to Kelantan State Government, approved by the Kelantan State Government, and never delay in paying the tolls consistent with Section 48A of the NLC. Therefore, the appellants come with clean hands and follow the law, and is hereby the equity applied. Therefore, the appellants can claim their right in equity since they follow the law in occupying the land and they stay in the said land with clean hands. That's all from me. Thank you.
Good morning, Arif. May it please this honorable court. My name is Wan Amirul Arif bin Marosli, appearing as the junior counsel on behalf of the appellants. Yeah, Arif, I will be dealing on the second issue, which I will divide it into 3 parts. For the first part, the respondents are not allowed to enter the said land area without the appellant's permission. The self-help remedy by the respondents cannot be imposed on the appellants. In Siddiq bin Haji Muhammad and Government of State of Perak, the court held that the appellants were categorized as squatters simpliciter. Thus, the land's legal owner was entitled to take the self-help remedy without the aid of the courts. In contrast with this current case, appellants were occupied with license who had exclusive right to legally occupy the land. Hence, they were not considered as squatters simpliciter since the toll granted was valid until 2015. Thus, the respondents are not entitled to use self-help remedy to go into the said land. Next, the right of toll holder exclude others during valid toll period. Subject to Section 44 of the National Land Code, the toll holders have possessory right, allowing them to have exclusive use and enjoyment over the land. In Julaica Bibi and Maidin, toll holders has right to exclude others from unlawful interference with the right conferred. Next, in Muhammad Said and Fatima, the valid period of license give licensee the right to immediate and exclusive possession to the land. In present case, appellants were in the valid period of toll has a right to eject others who interfere their possession over the said land. They have the right to permit others to enter their land. For the second part, the respondents has no right to eject the appellants out from the said land if they refuse to vacate the said land. The requirement to apply service of valid notice with reasonable time to vacate the land. In Zhou Lianhao, the court held that a licensee whose license is revocable is entitled to get reasonable notice for revocation. Further, in Yap Tai, the court provided reasonable time of the license takes effect upon toll holder to vacate the land. In present case, the notice to vacate only come to the appellant's knowledge in 2013. It is not considered reasonable notice since respondents did not specify the reasonable period to vacate. Furthermore, the undated notice by the respondents is considered null and void. In Yusuf bin Awang, the court held that the updated notice were null and void as it is important for the respondents to know when they were expected to leave. For the last part, the respondents are not allowed to use force if appellants refuse to vacate the said land, since promises created legitimate expectation. In the case of Yap Tai, if licensee choose to overstay on land, either because his license has expired, such person classified as being in unlawful possession of the state land. In present case, appellant is occupied with license, waiting for the promises made in 2013 by the respondents. Therefore, it is not allowed to use force against them if they refuse to vacate said land during the validity of toll period until 2015. Meanwhile, in Sepadan Dive Center Sdn case, the court had said that a substantive reasonable expectation occurs when an affected individual is dissatisfied with only having the opportunity to be heard and wants the benefit that he reasonably expected from the public body in question. In present case, the appellants had a legitimate expectation to be given a transit house. Thus, it was unfair for the respondents to use self-help remedy and force them out without fulfilling their promise that induced legitimate expectation towards them. Hence, we would like to submit that the respondents are not allowed to enter, eject appellants out, nor use unreasonable force against them if they refuse to vacate the said land. Having finished with the argument for the second issue, then that shall conclude my submission. Thank you, Yang Arif, for your time and indulgence.
Good morning, Yang Arif. May it please this honorable court. My name is Noorila Sharifah, appearing as the senior counsel on behalf of the respondent, the state government of Kelantan, and others. There are two issues to be submitted before this honorable court, as I'll be submitting the first issue. Appearing together with me, my junior counsel Fatima Azahra will further address on the second issue. Yang Arif, I'll be dealing with the first issue that consists of two parts, which are first, the appellants are not entitled and have no right in law to compel the respondents, and second, the appellants have no right in equity to compel the respondents to compensate and fulfill their promises upon the squatters. I shall now proceed with my submission. For the first issue, we submit that first, the appellants had acquired the title by adverse possession. By virtue of the Section 48 of the National Land Code 1965, it is provided that there can be no adverse possession of state land, where an unlawful occupation of state land does not enable the occupier to obtain title to the land even after a long duration of occupancy. In support with the previous provision, Section 341 of the NLC 1965 provides that adverse possession is not to extinguish titles, as the original owner can protect the title of the land against any claims of adverse possession by squatters. In relation to the contention above, the court in the case of Side and the government of Perak stated that the appellants have no cause of action against the respondents, as they were squatters who had no right either in law or equity as stipulated in the Section 48 of the NLC. Further illustrated, in Inmatek and Yong Tai Hung, where the plaintiff's title as the owner did not affect, although the defendants had been staying and occupying the premises for the last 40 years. As the court held that the defendants cannot claim adverse possession regardless how many years had the defendants occupied the said land. In referring to the relevant provision in the case, it is proven that squatters could not obtain title to the land even after a long duration of occupancy by the factor of the unlawful occupation of state land. Hence, in applying the provisions to the case at hand, although has contended that the appellants as the squatters had acquired the state land by adverse possession, however, they were not entitled and thus had no right in law as stipulated under Section 48 and Section 341 of the NLC, to compel the respondents as the owner of the state land for fair composition and fulfill the promises that have been made against them. Secondly, the appellant was squatters in illegal occupation of land, where the word squatter is not used. Instead, unlawful occupation and adverse possession that is used in NLC in regards of the squatters. As provided in Section 425, in subsection 1 of the NLC 1965, squatters can be defined as the ones who do activities on a piece of land without law authority or without permission, or namely illegally. Besides, we would like to draw this honorable court's attention to the relevant cases involved. First, in the case of Tenaga Nasional Berhad and Vijayalaxmi Subia, the court has referred to the definition of squatter in Bukit Lenang and Penduduk-Penduduk Mukim Plentong, which squatters were defined as a trespasser who enters upon others' land and remains thereon to the detriment of the present owner. Furthermore, in SIDE and Government of Perak, the appellant's appeal was dismissed on the grounds that the appellants had no cause of action either in law or in equity as there were squatters in respondents' land. Moreover, in Dato' MBSA and Yusof, the court cited from SIDE's case that the occupiers have no right in law or equity since the squatters had failed to show that they were in lawful occupation of the property. Applying the provision to the present case, the appellants cannot compel the respondents to fulfill their right in law as they were the squatters that were in unlawful occupation. Hence, the appellants shall not have the right in law or equity to claim as such and what they have been promised by the respondents in the paragraph 8 and 9 in the moot problem. From the cases above, it is clear that the appellants have no cause of action against respondents as there were squatters in illegal occupation of state land by which they had been illegally occupied and settled in the state land area of the respondents. As for the second ground, the appellants have no right in equity to compel the respondents to compensate and fulfill the promises on the squatters. By the case of Leby and Chung Woi Lung, the appellants as squatters argued that they had peaceful enjoyment and occupation before the land was alienated to the respondents. Moreover, in SIDE and Government of Perak, this honourable court observed that a court of equity will never assist squatters to oppose an order of possession obtained illegally as it will never intervene in aid of the wrongdoers. Therefore, to clarify the above contention, the court acknowledged the principle of ubi justibi remedium, where it means those who come to equity must come with clean hands. To apply in the present case, since the appellants were the squatters, consequently they were not entitled to the equitable remedy since it will never assist squatters in illegal possession of land. Hence, we would like to submit the appellants had no right in equity as squatters, which is not possible for them to succeed in any claim on equitable right as any legal nor equitable rights in Malaysia does not specifically provide for squatters. Having finished with this first issue, that shall conclude my submission. Thank you, Yang Arif, for your time and indulgence.
Good morning, Arif. May it please this honorable court. My name is Fatima Azhara, appearing as the junior counsel on behalf of the respondent, the state government of Kelantan and others. Yang Arif, I will be dealing with the second issue, which I will divide into two parts, which are first, the respondent can enter the state land and turn the appellants out if they refuse to vacate the state land. And second, the respondents can use force against the appellants to vacate the land. For the first issue, we submit that the appellants were in breach of the condition under Section 67 Clause 3 of the NLC. By virtue of the section, it is provided that toll is subject to the conditions stated in the license issued. This is further supported by Form 4A, Paragraph 4, which provides that land under license may not be used for the erection of any permanent building. In relation to the breach of condition in this case, the court in the case of Uda Holdings and Koperasi Pasaraya state that toll was an effective legal document that all parties had to recognize unless it was deemed illegal by a court of law. Due to the above factors and the legal restriction mentioned, and which the plaintiff had not accomplished, having regard to the relevant provision in the case, it is proven that toll cannot be recognized if the land is used not in accordance with the conditions stipulated in the license. In applying the provisions to the case at hand, the appellants built permanent buildings on state land that served as their proper house, and they did not have toll at the time. Hence, the action is illegal under the law because toll cannot be used for the erection of any permanent building. Therefore, it is proven that appellants were in breach of the condition under Section 67 Clause 3. And the consequences of the appellant's conduct have led to the termination of the toll, which then the state authority may cancel the license immediately without paying proper compensation upon the breach of the provision following Form 4A, Paragraph 5. Secondly, the appellants have been given adequate notice to evacuate the land. we would like to bring this honourable court attention to the relevant case. In the case of Yusuf bin Awang and Dato' MBSA, notice was sent to the appellants under Regulation 10 of the ECSR 1969, which state that occupying the land was an offence and that the appellants must vacate the land or face further action. Applying the law in this area to the present case, the appellants cannot allege a lack of notice because Yang Arif, if I may bring this honourable court attention to the moot problem, page 2, paragraph 6, the appellants have been required by the PKENK to vacate the said land in 2013. The notice to vacate the land was in 2013. Therefore, they should have prepared to move out, but they refused and took no action. From the cited case, it is manifestly clear that the respondents can take action against the appellants, and the appellants' act of remaining on the land is illegal under the law. Thirdly, the respondents are the owner of the land. Section 341 of the NLC provides that adverse possession of land for any period of time shall not prevent the bringing of any action to recover their interest. And Section 92, Clause 1 of the NLC provides that alienation of state land to any person or body under final title confers an invisible title to the land on such person or body. In applying to our current situation, the appellants are not entitled to prohibit the respondents from recovering their interest as the land has been alienated to the PKENK and thus confers invisible title to the land. Hence, the respondents have the right to go in and turn the appellants out since the alienation of the state land to PKENK was valid. As for the second ground, the respondents can use force against the appellants to vacate the land. By virtue of Regulation 4 of the ECSR, the local authority may demolish squatter huts on state land, and Regulation 3 defines squatter huts as a house, hut, shed, or any structure attached to any building that has been erected without a license. This is supported by the case of Shamsuddin and DBKL, which the court ruled that the local authorities might exercise the summary power of the regulation to demolish squatters without providing notice. So in our current case, although the respondents have given the appellants notice, this rule can also be applied because the appellants already satisfy the definition of squatters, huts as squatters. Therefore, in accordance with the Regulation 4 of the ECSR, the respondents may use force to demolish the house. Hence, we would like to submit that the respondents have the right to go in and turn the appellants out, and they can use force against them if they refuse to vacate the state land. Having finished with the argument for the second issue, that shall conclude my submission. Thank you, Yang Arif, for your time and indulgence.